Right, so we are about to start.
Okay.
When Mr. Professor Dr. T.R Subramanya, Dean CMR University School of Legal Studies, Bangalore, is there, you would have quite sure that session would be engaging, as well as it would have some directly or indirectly some reference of the environmental law. But today's session, more specifically, while we celebrate the 75 years of Constitution, discusses about the environmental challenges in India. We are glad that though we were trying incessantly that Sir should come on the session, but because of some health challenges, Sir, as soon as he got well, he has agreed upon it, and we are so glad that he's hale, hearty. And I was just talking that Sir is in better shape and with better vigor. So the challenges in respect of the health have gone. We also want that the environmental challenges go as such also. Thank you, sir. Wishing you all the best of health for future, and you keep on sharing the knowledge on our platform. Over to you.
Very good evening to all of you present here. Mr. Vikas and your team. Today's topic is the prevailing environmental law challenges. Now, most of you are interested to know what exactly are the environmental challenges of the present day. I was just reading a book on jurisprudence, which has a bearing on research methodology. And in this book, the concerned writer was just examining and analyzing the social purpose of law. So every law, when it is enacted, there will be behind it, there is a social purpose. Without a purpose, no law can be enacted, nor its presence is required in a civilized society. So is the case with environmental law. Now, law is enacted not only for social purpose, but to create self-confidence. It is created for self-confidence for the simple reason that the people who obey the law and the people to whom it is thrust upon and who are supposed to be the subject of that law should be in a position to survive and act with the confidence. So that is another object and purpose of the law. Now, when we speak about environmental law, generally, remember, it is an interdisciplinary approach and an interdisciplinary subject. When we speak about environmental law, a lot of issues come in. Now, you may be interested to know what exactly are those issues which come in inside and outside the purview of environmental law. Now, for example, these days, hazardous waste is a subject, remember, which is concerned with the environmental law. And hazardous substances is another area which is also has a great concern with the promotion and protection of environmental law. And then genetically modified organisms and its transportation to one country to another, and the biodiversity. These are many, plenty of them. Half an hour you can give the list. You can just list them, which are the subjects matter that actually come within the scope of environmental law. Now, when these subject matters come under the scope of environmental law, especially for the teachers who teach environmental law, naturally a problem may come up. Now, the problem is of what type? The problem is, remember, it is a very terrible problem. For example, at times a teacher may face what to teach under environmental law. Then to be taught from which point of view, from which angle? Should it be taught from the multinational company's point of view? Should it be taught from the developing countries' perspective? Or should it be taught from the poor, underdeveloped country whose per capita income is not even 50 rupees? So it is an inhospitable situation wherein the teacher who teaches environmental law has to balance Now, in addition to this, some of the teachers may put a question onto themselves. Why a subject this nature should be taught? So these are all challenges which are being faced by the teachers. Then what exactly is the social sensitivity of this subject? And should it be taught from the human rights angle? Or should it be taught from the capitalist perspective? Should it be taught from the social justice or the communist perspective? Now, these are all some of the challenges which are being faced by an environmental law teacher, and these challenges are not only for the teacher but for everybody, and mainly the environmental law itself. Now, when we take up this matter, I just intend to speak to you, bring home a few of the things which are essentially are to be tackled by a teacher when he deals with this. Unless these challenges are raised and a proper response is given, and if it is properly answered inside the classroom or in a public function when you are asked to speak, no solution is given to such a problem. Now, when we take up this matter, take it this way. Now, one fundamental problem that is being raised under the present day law, many of the teachers, when they go to the classroom, they don't even bother to make a mention of the contribution of the Supreme Court of India. Now, naturally, you might be knowing since 1976. Why I say 1976? Till 1976, there was no concern for environmental law in this country. We always used to speak about ancient books. And these ancient books, right from the time of Kautilya's Arthashastra to the end of the 19th century, spoke several things where an environment has to be protected. And it is very much essential for the survival of humanity. But then when we come to the 20th century, a few of the countries wanted to codify the existing rules of environmental law. And they intend to codify this environmental law, and having, remember, codified, they started enforcing it. But India did not bother about it. The constitution came to this country on 26th November 1949, came into force on the Republic Day in 1950, the subsequent year. But then hardly there was any article in the Constitution of India relating to the protection of the environment. Now, when I speak of this, it is only in the year 1976, they introduced what we call as the 42nd Amendment. Now, when they introduced the 42nd Amendment, they provided actually two articles. Now, one of the articles that came in under Chapter 4 of the Constitution of India. Now, Chapter 4, it relates to directive principle state policy. In this chapter, an article was introduced which is called as Article 48A. And the Article 48A now it reads, the state shall endeavor to protect and improve the environment. So it is the duty of the state, because it is the word shall is used. The state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife. It is not enough. It makes an attempt to safeguard the forest. But then you should protect the forest and the wildlife of the country. So I can just give you, in 1972, a report was submitted by the United Nations. This report was naturally based on the report which was submitted by all the states who participated in the Stockholm Conference of 1972. So in this report submitted by each state, and it was collected and collated by the Environment Commission, the World Environment Commission, remember, went to the extent of pointing out there were, before 1972, 8.2 million species. Of the 8.2 million species of the world, remember 8.1% of it, the 8.1% of the 8.7 million, not 8.7 million species were in the state of India. That was considerable. Now that means what? Almost all the states in their report indicated that the species have disappeared. And some of them, remember, completely exhausted, extinct. And remember, it has to be regenerated. So it was an inhospitable situation. And that is where, in the 1972 conference, they went to the extent of canvassing for this. You have to protect the environment. You have to cultivate the forest. You have to, remember, protect the biodiversity. You have to conserve the biodiversity. All these things came one after another along with the concept of sustainable development. Now the point is, there was another article that was introduced into the Constitution in the same breath. And what is this article? This article came in 51 AG. That is an article on fundamental duties. And this is slightly different from Article 48A. Now, Article 51 AG points out it is the duty of the government of the day to improve the natural environment. That means what? It was simply saying the natural environment is not up to the expected level. Since it is not up to the expected level, it has to be improved. Biodiversity should increase. Forest cover should increase. Remember, there should be a provision for the discharge of hazardous waste produced by the concerned state. Then, to improve the natural environment, including forests. So you have to improve the existing forests, increase the forest cover. Then you have to protect the lakes, rivers. It was not mentioned in 48A. So rivers and lakes are very much essential. You may ask me why rivers and lakes. Now, after 1972, several reports came in. When these reports came in, now what was responsible for the tsunamis and the rise in sea level, as well as earthquakes? The study that was conducted for the response for in causing earthquakes as well as tsunamis was nothing but the disappearance of biodiversity. In large number of states, including Latin American countries like Mexico, Argentina, Chile, Ecuador, Peru, all of them, there was huge forest cover. Now, a particular scholar on forests gives the statistics in the ancient time, 8 million years ago, the forest cover, world's forest cover was almost 47%. So that means what? 47% of the forest cover was good enough in the world for the world and for the world. And that much coverage, remember today, it has decreased to palpable and miserable statistics. We can't just, how much are disappearing? At the hands of whom? For what reason? Best known to the people who do it and who take it and ultimately destroy the forest cover. So in order to increase the forest cover to prevent earthquakes and tsunamis, they enacted a law which is known as the Convention on Biological Diversity at the United Nations level in 1992 itself. And here in 1972, they said to protect and improve the natural environment, including forests, lakes, rivers, wildlife, most important. And to have compassion for living creatures. So it is not enough if you cultivate wildlife and allow them to be inside the forest, but then you should have compassion so that they live and let others also live. Remember, these are certain things which are being spoken. Now, the very purpose of saying this is, so the concern for environmental law came in 1972. Now, but at the international level, remember in 1972, the Stockholm Conference came in. And in the Stockholm Conference, I just intend to speak to you only 2 or 3 articles I will just point out. The Stockholm Conference, which took place in 1972, was participated by 113 states. And 113 states attended and deliberated from June 1st to June 15th, and deliberated on many things, many aspects. And they deliberated on many aspects. Remember, after the deliberation, when it was complete, they were able to adopt what we call as the 26 principles. And these 26 principles became the guiding principles of environmental law, international environmental law of the future. All the participating states were asked, requested, and they were, remember, given the task of enforcing what was indicated from Article 1 to Article 26. I just intend to speak to you only about 3 or 4 articles, not beyond that, because it's not possible. 26 principles, if I still speak, it will take at least 2 hours. Article 2. Article 2 of the Stockholm Declaration of 1972 pointed out the resources which are found in each jurisdiction of a particular state must be safeguarded for the present as well as future generations. So the resources which are found in each territory of a particular state must be safeguarded for the present as well as future generations. That means what? The concept of sustainable development was recognized in Article or Principle 2 of the Stockholm Declaration. But the concept of sustainable development, by name as sustainable development, came in 1985, only after Madam Brundtland gave her report on common future. Because there is a report on sustainable development. Although the concept of sustainable development came in really and legally in 1985, it was recognized in Principle 2 of the Stockholm Declaration. That is what I just wanted to harp upon. Then you have one more principle. This principle is known as Principle 7. Principle 7 of the Stockholm Declaration earnestly requested the states to prevent pollution of the seas. More the pollution of the seas, more the rise of what we call as sea level water. Because all the pollutants from all the countries are released into the seas. And because of this, because of the chemicals, because of the hazardous substances, because of the nuclear waste, because of the battery waste, whatever you say, this has resulted in the rise in the sea level and the destruction of biodiversity. That is why Principle 7 said to prevent pollution of the seas, you cannot release whatever you want to the seas. It is just not possible. It is most unwelcome. Now there is one more, that is Article 20. And what Article 20 of the Stockholm Declaration, it pointed out, remember, there shall be scientific research at the national and international level. Now I am raising this because it is a challenge today. Now scientific research to see that the environment is kept clean and the greenery is always found in the environment, researches has to take place at the state level, at the members level, at the international level. So it went, for the first time, it went to the extent of harping upon technical assistance must be given to states, to those states which don't have technology at all. So we use technology in everything today, and it was utilized, and its need was felt, and its need was recognized by the developed world, and they said it should be shared with the developing countries so that there will be lesser pollution and there will not be much problem related to environment-related matters. So that was one of the principles. Now, thereafter, there is one more principle which I just wanted to speak to you. Principle 6. Now, Principle 6 pointed out, in the event of any problem, notification to other states are to be given. Now, I will give an illustration so that you come to know what is this notification is all about. Now, for example, this became a law in the year 1987. Now, what has happened was soon after the glasnost and the perestroika in the state of Soviet Russia, many states seceded. And Georgia, who again was an independent state, is an independent state now. In Georgia, most of the erstwhile Russian nuclear submarines were kept. So afterwards, when Soviet Russia, remember, many states became independent. What has happened was these nuclear submarines, which are kept only in Georgia, were not serviced. And since they were not serviced, what has happened was there was slowly and steadily from these nuclear weapon submarines, radioactive waste, remember, started coming out. And these radioactive waste slowly and steadily, remember, go into the air, and then they get into what we call the Scandinavian countries like Norway, Denmark, and Sweden. Oh, Norway, Denmark, and Sweden slowly, and so they came to know and they started worrying, and they complained to the International Atomic Energy Agency. And when they complained to the International Atomic Energy Agency, for the first time, the International Atomic Energy Agency, established in 1967, went to the extent of issuing a notification. This is called the early notification. In the event of any danger which is being caused in a particular state, that state wherein the danger has originated should be in a position to inform the nearby states, saying that something is likely to happen and you have to take precautionary steps. See, that is why precautionary principle came in. Otherwise, nobody knew about it. So in order to take the remaining precautions so that the humanity survives, the state subjects survive, a note was issued by the International Atomic Energy Agency, then it became a law. Now, one more article I just wanted to point it out. This is the most important article, Principle 21. Now, here comes the challenge. Principle 21 simply points us today, Principle 21 is called as a jus cogens. It has become a customary rule of international law. Now, what does it say? It says states have sovereign right, and this sovereign rights to jurisdiction, to expel and admit aliens, to many other things, remember, is not extended to encroach the sovereign rights of another state. Suppose, for example, state has sovereign rights to do what it wants, sovereign rights to, remember, protect itself, sovereignty, independence, equality. This is one of the basic rights of a particular state. But then this sovereign rights to independence, equality, and self-preservation is not extended to harm the environment of another state. If it is harm to damage the environment of another state, remember, it is a clear violation of international law. Now, this is called no harm rule in international law. So on the concept of sovereignty proper, remember, a limitation was imposed. And this limitation is you are sovereign, no doubt, do what you want in your jurisdiction. But then this right is not extended or not allowed to be exercised in the territorial sovereignty of another state. That will be viewed very seriously and there will be repercussion. Now, the point is this principle is being harped upon and considered as a customary rule of international law because this is being recognized in almost all the major environmental law conventions. If time permits, I shall just speak to you a little later as and when I keep telling about this. Now, under the present day international law, you might be knowing, the first case came in before the court happened to be a case between the state of United States as well as the state of Canada. And the name of the case happened to be a trial smelter arbitration case. Those who teach international law, those who teach environmental law are aware of it. Now, what has happened was a particular factory, trial smelter, which was carrying on its activities in the state of Canada. And this factory was just situated in the state of Canada, bordering the state of United States. The company, remember, it was dealing with the chemicals, naturally used to release lead, zinc, and sulfur dioxide. So the zinc, lead, and sulfur dioxide that was released, remember, slowly come into the borders of the state of Canada, which was just 11 miles from where the company was functioning. From 11 miles, remember, it would enter into the Columbian River Valley. Having entered into the Columbian River Valley, it would go to the state of Washington. Having entered the state of Washington, these noxious fumes, deadly fumes, damaged timbers, damaged biodiversity, damaged agriculture, and damaged fishery resources. Now, the state of United States came to know because the factory was established in 1929. And in 1933, they came to know about it, and just the United States was surprised. They said, we are living in peacetime. In peacetime, what is this the state of Canada is doing? We don't have any differences. Without, irrespective of the differences, it is releasing into our territory noxious fumes. And immediately, the cabinet subcommittee of the two committees met and they requested each other, Canada, to stop the releasing of noxious fumes to the state of, into the river Columbian Valley. But then the activities, remember, continued by the state of Canada. In 1937, the state of United States became serious. And when they became serious, naturally, remember, the matter was referred to a settlement on arbitration. Now, the Court of Arbitration found Canada guilty, and for which it had to pay compensation. Now, imagine how many incidents and instances of this type take place between the states. This is a norm of international law. But then this norm is, remember, either loosely observed. Now, only one case I will explain, because if I start explaining, there are plenty of cases before the ICJ, decided by it. But one has to be pointed out so that you come to know the point better. Now, what has happened was, in 1974, the state of France exploded thermonuclear weapons. And when it exploded, remember, atomic thermonuclear weapons, Australia as well as New Zealand, they were taken by surprise. And they were taken by surprise because due to the explosion that was caused and done by the state of France, the radioactive waste actually were in the coast of Australia as well as New Zealand. And since the radioactives were found in the coast of Australia as well as New Zealand, they go before the International Court of Justice. Having gone before the International Court of Justice, they seek the International Court of Justice to serve an injunction to stop the explosion of nuclear weapons. Now, the state of, remember, France, being a member of the Security Council, appeared and said, in future, we will not do. Somehow the matter came to an end. Now, the state of Australia as well as the state of New Zealand came before the International Court of Justice, saying that here is a case wherein we are representing the global commons. We are representing the global commons along with our nationals, the nationals of Australia as well as New Zealand. Because, remember, sea is full of resources. And these resources are being utilized by everybody. And these resources are being damaged because of the nuclear weapons exploded by the state of France. That is why we have come as global, representing the global commons before the ICJ. Now, thereafterwards in 1990, the state of New Zealand got the apprehension that the state of France is going to explode nuclear weapons again. So at that time, it goes before the court of law, that is the International Court of Justice, and requests the court to direct the state of France to conduct an EIA, Environment Impact Assessment. See, this was done in 1991. Why I am making a statement is in 1992, 1993, EIA came to India also. Before any project is carried out, there shall be EIA, Environment Impact Assessment. So New Zealand says, please direct the state of France to conduct an environment impact assessment before any explosion it does in the Pacific Ocean. Now, judges International Court of Justice, remember, deliberate the matter, and afterwards, majority of them, they say, we don't have jurisdiction. That is fine. But then, although they said we don't have jurisdiction, there were 3 judges of the International Court of Justice who gave dissenting opinion. And these 3 judges gave dissenting opinion. Remember, all of them were top-class judges. One happened to be Justice Palmer. The second one happened to be Justice Veeramantri. And the third one happened to be Justice Koroma. Now, Justice Palmer pointed out, you just look to the history of the development of international environmental law. If you look to the history of the development of international environmental law, right from the Stockholm Conference until the Rio Declaration in 1992, a series of principles are adopted. And these series of principles today have gained the place of jus cogens, you may say, or customary rule of international law. And principle 21 is one such. Principle 21 is one such for the simple reason. Remember, you have the sovereign right to do what you want, but then you cannot encroach the sovereign rights of another. So he went to the extent of pointing out this has to be remembered by everybody. Now, Justice Veeramantri, he went to the extent of pointing out in his judgment, in all cases, EIA is very much essential. In matters pertaining to environmental law, EIA, Environment Impact Assessment, is very much essential. Now, the third man, Koroma, he went on to argue. Remember, although today it has attained the status of customary rule of international law, most importantly, in all environmental document, Principle 21 is being referred. And Principle 21 has to be obeyed and respected by all the parties, including the state of France. The point is, after that, there are plenty of instances and incidents. Plenty of conventions are adopted at the international level. And these are all made for observance, not for cruel joke. It's not a cruel joke because a lot of deliberations go on before a convention is adopted. In spite of adopting these conventions, remember, there will be violations that is taking place. I shall just give you just a hint of a case which was decided in 2010 between Argentina, Ecuador, and Chile. Now, the river Ecuador naturally divides the state of Ecuador as well as Chile. Now, in the mouth of the river, remember, there is rich biodiversity. The mouth of the river is used, the water is used for drinking purposes. It is used for touring. Oh, happy weekends are spent there by boats and all machine-made frigates, etc., etc. Now, the state of Ecuador, remember, wanted to establish 2 pulp mills on the mouth of the river. When it wanted to establish 2 pulp mills on the mouth of the river Ecuador, the name of the river is River Ecuador. Now, the other neighbor, Argentina, got worried and it goes to the ICJ. Having gone to the ICJ, if the state of Ecuador is allowed to construct, remember, 2 pulp mills, entire environment will go and it will be a disaster for both the countries. There will not be any tourism. Water is undrinkable. Biodiversity will disappear. Fishery resources, remember, will be washed away. So a notice was sent to the state of Ecuador. Ecuador just said, no, we don't have any intention. We only thought of it. Now we abandon. And then the matter came to an end. Now that is what I wanted. This is one of the challenges in enforcing Principle 21 of the Stockholm Declaration. And this principle was part of the Rio Declaration in Principle 2. Principle 2 of the Rio Declaration points out this. States have the sovereign right, but then it is not extended to, remember, harm the sovereign rights of another state. Now, thereafter, the Biodiversity Convention in Principle 3, Article 3, it points out the same. The sovereign right of a state must not be infringed by conducting an act which is expeditiously malicious. That is what the International Court of Justice in one of the cases pointed out. So this is one such instance which I just wanted to speak to you. Now the second instance happened to be an instance relating to the Supreme Court. Now when we speak about the Supreme Court of India, most of us, we go to the extent of finding out that the Supreme Court of India naturally is the protector of the environment. When it is the protector of the environment, remember, you just look to most of the decisions which are delivered by the Supreme Court of India. Now today, the role of the Supreme Court, as is pointed out by the wonderful scholars, Supreme Court has acted like a public educator. It has acted like a public educator. It has acted like a policy maker. And it has acted and is acting as a super administrator as well. Now, you may ask me a question, what is this? What do you mean by public educator, policy maker, super administrator? I shall explain to this matter only for purpose of understanding. See, the development of environmental law through the jurisprudence of the Supreme Court of India is inestimable. Remember, it has given such wonderful judgments. And it is a public educator, simply means, remember, in one of its decisions, it pointed out environmental law in this country has to be taught at the lower level itself. Remember, when you are in the primary education, there should be a concern. When you go to the secondary, there should be some pages on environment. So that every citizen of this country must be a protector of environment. That is why it is the public educator. There are wonderful things. Now there are afterwards, you may say, policy maker. When I speak about this policy maker, I will give you a beautiful case which was decided by it, Jagannath versus Union of India. In Jagannath versus Union of India, which was decided in the year 1996, the Supreme Court came heavily and pointed out, in all cases from now on, you have to use unleaded petrol. So you might be knowing unleaded petrol, because lead is dangerous to the health. And it is, remember, the toxic effect of this is deadly. So when we use, remember, refine it in such a way. Refine the crude in such a way, and when it is converted into petrol, there shall hardly be any content of lead. So that is what, remember, it is one of the policy makers. Now there came before the Supreme Court of India a beautiful case which is known as State of Himachal Pradesh versus Ganesh Woodworks. State of Himachal Pradesh versus Ganesh Woodworks happened to be a decision of 1996. Now in this case, remember, for the first time, it pointed out whenever a matter pertaining to environmental law comes in, what is important is, remember, what type of policies the concerned state has adopted relating to environment. First one is related to the policies of the government related to environment. And then the laws which are adopted by the environment to enforce these policies. Then the law which is enacted and the policy that is adopted by the central government. Then the third important thing is the concept of sustainable development. The concept of sustainable development is another major concept that was introduced. Now, the most important that is being spoken is principles of intergenerational equity. Now, what is this intergenerational equity? Now, resources are scarce anywhere. Today you may find, 5 years hence it may disappear. So it is the duty of everyone, it is a moral, legal duty of everyone to use the resources not in plenty, only to the extent which is required, and to preserve for the generation which come after us. The concept of this concept, intergenerational equity, is a continuing concept. It is a continuing concept for the simple reason. In our generation, we try to preserve. We use to a limited extent. The generation which come after us will use only at a limited extent. Then generation and generation which come after them also has to follow and obey this concept. So nicely it was pointed out by the Supreme Court of India. Remember, that is where we say it is a super administrator. Now, it is not over. There are, you remember, many other cases as well. In 1987, the famous oleum gas leak came in. And this came in in Delhi. There was a leakage, and a matter was challenged before the Court of Law in the Supreme Court. It landed before Supreme Court. The Supreme Court, for the first time, introduced the doctrine of absolute liability. That is what I'm saying, super administrator. Principle of absolute liabilities. For example, in Reland versus Fletcher, for the first time, not in Reland versus Fletcher, in Donogh versus Stevenson, for the first time, remember, in 1868, what we call the principle of strict liability was said. And the principle is very simple. If you bring any dangerous thing to your premises, if you keep that thing at your peril, so nicely it is put. If you bring any dangerous thing to your premises, you keep that thing at your peril. Similarly, they said, if the manufacturer manufactures an item which is deadly and dangerous, and when it is stored after manufacture, if it leaks, remember, and goes down to the nearby area, the liability is absolute, and the cleanup operations has to be conducted at the expense of the factory owner. Not only the cleanup operations have to be conducted, the environment has to be done status quo ante, how it was earlier. You have to bring it to the status quo ante position. That was what the Supreme Court said in the Delhi oleum gas leak. Then there was another case which came in, and this case happened to be B.L. Vadhera versus Union of India. Now, always when a B.L. Vadhera versus Union of India. Now, in this case, what has happened was the enforcing agencies, maybe the Pollution Control Board, or maybe other departments of the government, or maybe the corporations which are found in the main cities. Whenever a case of non-observance came before it, always they used to plead, we don't have funds. We don't have employees to enforce. So always they used to say, we don't have personnel to enforce the environmental laws that are passed by the government. We don't have, remember, adequate staff. We don't have adequate money. Funds have not come. Probably this year we may apply, next year we may get. Now in B.L. Vadhera versus Union of India, Supreme Court, remember, expressed its anguish. The enforcing authorities in every case, if they come and plead that we don't have staff and we don't have money, then what for? The law is enacted. And the Supreme Court, they said, such plea will not be entertained. You are liable and you should get the money or you should employ the people and enforce the existing provisions of environmental law. Unless you do that, remember, we are not going to listen. This became a warning and it became a model. This is one important aspect. Then there came another case which is known as Banwasi Seva Ashram versus State of UP. This came in the year 1981. Now, what has happened was the Thermal Power Corporation of India wanted to establish a thermal power station in what we call as Banwasi Seva Ashram in the state of UP. Now, that area, Banavasi Seva Ashram, is full of what we call as the scheduled tribes as well as the indigenous people. And all the indigenous people who are living there for thousands of years were made to vacate. They were not given alternative, remember, lands. Where to stay? You may be knowing in Narmada Andolan case, Meda Fadkar fought because when the Narmada Dam was about to be constructed, many people were asked to vacate and they were thrown and some of them ran away to Maharashtra. So at that time, the agitation started, unless you give them land, where will they go, what they should give, who will go, or who are going to give appointment. So similar thing has happened in 1981 and the Supreme Court pointed out, you cannot drive away the indigenous people. If you want to drive away the indigenous people, naturally, remember, you have to give alternative place of stay and accommodation. And they are the indigenous people. This cannot be done. So this is another far-reaching policy which was adopted by the Supreme Court of India, and the challenges were effectively answered. Now the other one is prevention of pollution from the source. What do you mean by this? Now, if you just study the cases and the jurisprudence of the Supreme Court, in most of the cases, it pointed out, now the only way we can prevent pollution is it should be prevented from source itself. Now, factories which release should be in a position to have what we call as the dumping grounds. And these dumping grounds should be scientifically be established. And from there, it should not escape to the nearby land, as has happened in Reliance versus Fletcher. Now, all these precautionary measures were taken. Then after that, adoption of new technology. When I speak about adoption of new technology, you know this. For example, today, most of us drive vehicles. When we drive vehicles, you may be knowing Bharat 1, Bharat 2, Bharat 7, it has come to now. Or maybe 8 also, I don't know. And similarly, Euro 2, Euro 7. Now, as and when the technology improves and comes to the market, it is the duty of the manufacturers to introduce this technology into the vehicle. Lorries are also supposed to introduce. No, the liability is put on the manufacturers because a owner of a car or a driver of a car may not be in a position to put it in his vehicle. It is just not possible. We can't expect it. That is why the concerned person, the manufacturer, the industrialist should itself put this technology. So that is the adoption of new technology has to be done. This is a policy which was adopted by the Supreme Court of India in protecting the environment for our sake. Then there you have what we call as Damodar versus Municipal Corporation. What has happened was in Hyderabad, the municipal corporation has allocated some money. And this money, land, for purpose of having beautiful gardens so that children and the elderly retired ones go there and play in the evening or stay there and enjoy the time. And this is a huge area. Now, when it is a huge area in the heart of the city, meant to preserve greenery, remember the income tax department as well as what we call as the LIC, Life Insurance Corporation of India, wanted to snatch away this land. They wanted to take this land and wanted to have what we call as the housing society. And the matter was challenged before the court of law. In Hyderabad, in the vicinity, it is a huge city. There are lots of elders. Simultaneously, there are lots of youngsters. All of them, they need, remember, good environment to live in and garden under gardens. Now, this, if it is taken away for the housing society purposes, for the income tax department, for the power they wield, and LIC of India, the very purpose gets defeated. It cannot be done. And the courts agreed on this matter. The objective for which the land is allocated, it pointed out, if for a purpose something is done, that it is the duty of the law enforcers to see that the object is realized. It cannot be achieved other than what is indicated by way of a purpose. That is what the Supreme Court pointed out. Another case came up. It is called as the Bangalore Medical Trust versus SB Muddappa. In Bangalore Trust versus SB Muddappa, the answer was very simple. Land was allocated for purpose of having beautiful gardens in Bangalore, that is in the garden city. Now, one fine morning, you find the land is encroached, and the encroached land happened to be for the establishment of a medical college that is known as Bangalore Medical Trust. And the public got enraged. They go before the court of law. Having gone before the court of law, they just plead it is just not possible because you have plenty of elders as well as children. They don't even have playgrounds. They go to the nearby gardens, and these gardens are set up by the corporation. How this land can be given for a medical hospital? Who is going to take care of the hospital waste? And provisions are not even made. How this is possible? The court, remember, admitted their contention and accepted it and rejected to have what we call as a housing complex. Sorry, medical complex. Now there came another, what we call as the Abhilash Textiles versus Rajkot Municipal Corporation. It's a beautiful case. Now these are the cases through which the Supreme Court developed the environmental law and its jurisprudence. See, the point is, most of the challenges, when it came, the Supreme Court answered it in such a way. Now, in Abhilash Textile Corporations, remember, Abhilash Textile Company versus Rajkot Municipal Corporation happened to be a case from Gujarat. Now, Abhilash Textiles happened to be a textile company situated in Rajkot. It had employed more than 25,000 people. And the company, because of manufacturing saris as well as other important salwar kameez, etc., for women, it used to make use of color. And the color that is being made use of happened to be deadly and poisonous. The hazardous liquid waste generated during the production of saris or other important items were released in the vicinity. And the entire vicinity was with liquid waste. And the corporation tried to, remember, compromise the matter, but then the company was not listening at all. So the matter was pursued before the higher court. And when the matter was tried before the higher court, the company pointed out, these employees have been living for 25 years. 25 years, 25,000 people were living in the midst of the liquid waste and did not complain. And every day it is being released. What would have happened? Many people would have died of cancer. We don't have statistics. And the company went to the extent of defending by saying under Article 19G, they have a right which is called as freedom of trade and commerce, freedom to trade. And this freedom to trade cannot be taken away by anybody because it is a fundamental right under the Constitution of India. Now the court got wild and it said, there is no fundamental right called absolute fundamental right. Every right is right with a reasonable restriction. You cannot release the hazardous substance liquid waste into the environment wherein your people are living. If you have released it for 25 years, you are all the more dangerous and stop the factory. This is the judgment which came in. Now, I just wanted to speak to you the public trust doctrine. The public trust doctrine, it was between Kamal Nath versus MC Mehta, wherein somewhere he wanted to, Kamal Nath as the chief minister wanted to divert the course of the river. The matter was challenged by the public before the Supreme Court of India. But at that time, the court pointed out, look to the civilizations of the world. All the best of civilizations starting from Indus Valley, the Nile, the Euphrates and Tigris, the Ethiopian Mesopotamian civilization, all of them have grown on the river bank. And these river banks were responsible in the growth of civilization. How can you direct the course of the river? And where the people who are inhabitants who are living on the side of the river, on the coastal side, where they should go? And the contention was rejected. And afterwards said, the entire sources, material sources which you find either in the river side or in the rivers or in the continental shelf, remember, belongs to the Union of India. You don't have any right to change it or to take it or to alter it or to destroy it. This is the way, remember, the Supreme Court in this case pointed out. Now, thereafterwards, I just intend to speak to you a few of the developments that have taken place in this country. Now, one happened to be the what we call as the polluter pays principle. The polluter, some question was there. Polluter pays principle today has become part of environmental law. In all the cases, if a particular person is responsible in polluting the environment, he is answerable. Now, there are two cases which came before the Supreme Court of India, which nobody makes a mention, including scholars and the teachers when they teach. Now, one happened to be a case known as, it's the Birchi case. Birchi happened to be a district, a place in the state of Rajasthan in Udaipur. Now, what has happened was in the 1970s, between 1970 and 1980, H acid, remember, earlier it used to be produced. And H acid is called as the naphthalene acid. Content is naphthalene. And which was used in providing color to what we call as the clothes. And because of the deadly poison involved there, almost all the developed countries, European countries, started abandoning it. When they started abandoning the use of H acid and its use in cloth to provide color, China as well as India, as well as the state of India, started taking it. And one such factory came in the state of Rajasthan in Birchi in Udaipur. And this was started, and thereafter it started using it. The factory started. The first month went on. In the second month, remember, there used to be pollution. In the third month, remember, the entire water became red. And in the fourth month, the entire groundwater became red. And the people had to import water even for drinking purpose, and it was contaminated with what we call as poison, several substances. So at that time, the matter, they go to the Deputy Commissioner's office and protest. Thereafter, they go approach the Pollution State Control Board. Then the matter was approached before Central Control Board. Then a writ petition was filed. And MC Mehta took up the cause at a later stage, and the case was decided. The case went to the court in 1989. And after 9 years, remember, the matter was decided. But then the compensation was awarded after 24 years. Remember, in 2011 or 12, the compensation was awarded. Now it was asked to pay 41 crores. And the environmental expert said that what was awarded is not enough. Then it was awarded 44 crores of rupees by way of loss to bring back to the glory which remained previously. The concerned factories were asked to be closed. They refused to close in the beginning. They used to shift from place to place in the same district. All of them were put to an end. And ultimately, remember, justice was restored even in this case by the Supreme Court of India. Now, the other important case happened to be what we call as another landmark judgment. Then this landmark judgment, what we call as the research study that was done. Now, what has happened was the state of India became a party to the Basel Convention on Transboundary Movements of Hazardous Waste. When it became a party to the Convention on Transboundary Movements of Hazardous Waste, remember, it participated in 1989 and the state of India signed in 1992. And then, in spite of the Convention on Hazardous Waste to which India was a party, the OECD, Organization of Economic Cooperation and Development, it was actually exporting hazardous waste into the state of India. No, at that time, Vandana Shua filed a writ petition under Article 32 of the Constitution of India, wherein she said hazardous waste convention at the international level has come into force, it came into force, and the state of India has become a party to it. How come? Without the acceptance and proper acceptance and permission, these hazardous waste is exported into the territory of the state of India for purpose of dumping or purpose of what we call as revival. Now, to clear it. Now, the investigation started. And when the investigation started, the Central Pollution Control Board said, sir, we cannot do this. We need a report of the expert committee. So with the result, the Supreme Court of India, with the assistance of the Pollution Control Board of India, appointed a committee. And this committee consisted of what we call 7 members. And Professor M.G.K. Menon became the chairman of the committee. And this committee was given 14 tasks. And these 14 tasks were taken into consideration, and it went on to personally study almost all the hazardous industries in this country and submitted the report after 4 years. It took 4 years. And a 4 years report ran into 1,200 pages. And it went to the extent of pointing out two things I just intend to speak to you. India did not have a landfill till 1997. And most of the landfills happen to be a very small size. And these small size were, remember, simply disposed with so many tons of waste, and ultimately they became, remember, large sites. From these sites, hazardous waste used to leak into the territory of another state or into the corner of a road. From there, it used to come into the open road. All of them are analyzed. And another important thing which is being pointed out, in most of the pollution control boards or in other bodies, we don't have clearly personnel with the knowledge of environmental law. The third one happened to be, there are several ministries involved. And these ministries involved have lack of coordination. They don't work together. Ministry of Finance, Ministry of Environment, and Ministry of Trade and Commerce. All of them, there are 8 to 9 ministries, Ministry of Agriculture, all of them, they are not in unison. And they don't come together. And they put their ideas. With the result, the matter is delayed for years. This is what it intended to say. And then most of the officials who execute don't even have knowledge of it. See, these are the challenges which I just wanted to say. Officials don't have training, and they are not being trained. You may ask me, what is your officials of what type? Hazardous waste, when it is exported by a foreign country to the state of India, the people who check it on the port should have proper training. If they are not trained, they will simply clear it and will go and pass through. And they have to be given training. They have to be given training in law, in science, in technology, and everything. And M.G.K. Menon in his report has pointed out, coordination is very much required between the ministries. Otherwise, for what purpose we have a law on this subject? These are a few of the things which I just wanted to say. Then the last point which I just wanted to touch upon happened a bit. See, the Climate Change Convention was adopted in 1992 at the Rio Declaration. Thereafter, the COP meeting has been taking place every year, and it took every year till 2015. Now they wanted to have a new convention on the climate change. So between 1992 to 2015, every year they used to meet. And in these conferences, every state used to meet. Every state used to contribute. Remember, just I am telling you, see the expenses which the state has incurred in these years between 1992 to 2015 in participating and deliberating. It will be, remember, huge money, few crores by each state. Now, why can't environmental law be studied under the Climate Change Convention from 1992 to 2016, because the convention came in 2016. Because in the year 2016, when the Climate Change Convention came in, there was some development of clean technology. Every state is supposed to provide the technology. A state which has the technology should provide. How many of them have given? The states which have technology have not given to the developing states or the least developed states. If they have given the technology, they have given the worn out technology, which is not good for anything. For example, the Vienna Convention of the ozone layer came into force in 1985. And the Montreal Protocol to that convention came in 1987. Under the Montreal Protocol, every state which has the technology should give the technology to come out and to see that fluorocarbons are released once for all. When Indian companies went and sought from certain multinational companies, they charged $25 million. $25 million. Now, one of the authors pointed out it is not 25 million, it is just 2,500 rupees. Because they are not giving the technology. If they have given, worn out technology is being given. And in the convention, you mention, remember, technology will be given, aid will be given, assistance will be given. All of them they speak. But then it comes to reality, it is not given, and it is in very, very bad situation. Remember, better if you don't even mention. So, but then developments have taken place between 1992 to 2016. What are these developments? What type of developments which the states have made? Whether anybody knows, any student of law, any environmental law students clearly makes a reference to the commitment which India has made. In the year 2016, it made a commitment. And the commitment is to see that it will spend $300 billion for what purpose? To generate alternative sources of energy. Most of the energy which is being produced today is of fossil fuel. And fossil fuel, remember, is deadly to the environment because it releases so much of carbon. When the release of carbon and its statistics came in, India releases 6% of the carbon which are released in the world. The state of China, 28%. And the European theater, that the European Commission, the entire European theater, all the 20 countries, they release almost 10%. And the state of United States, again, 16%. So we are releasing only 6%, but we have made a commitment. And the commitment that is being made is to produce alternative sources of energy. Alternative source of energy to the tune of, remember, 40%. Now, what is this 40%? 40% to 60%. Now, 60% you take it. What are these alternative sources? It goes to the extent of pointing out we should produce India by 2030, it should produce 100 megawatts of power through what we call as solar. And another 40% through what we call as wind energy. Another 10% of what energy we have to produce through what we call as not the wind one, biomass, through the biomass. And another 5% through what we call as hydroelectric energy. No, nobody speaks about, nobody knows this. Another commitment that was made by the state of India is India has to increase its forest cover by 5 million hectares. Whether anybody knows this? Now, knowing, you forget whether it is being, steps are being taken to increase the 5 million hectare land cover in this country for purpose of forest. 5 million hectares of land should come under the forest cover so that the entire environment is green. So that the temperature won't go up every year by 1.5%. These are a few measures which are taken by the country, the state of India, at the international level. I think this is enough. And if you have any questions, I shall answer if I. Thank you.
Just total. There's one.
Yeah.
The polluter must pay, principal succeeding in claiming damages from the developed countries.
Okay. Okay. Now today it has become a principle. Polluter should pay. But then if the earlier, when we were in colonies, if the colonial master has polluted and taken away. For example, I will give an illustration. In the earlier erstwhile state of Persia, 3 or 4 British companies have gone. And having gone there, they went on digging oil. And thereafterwards, remember, the state of Iran came to be established. Entire Persia was occupied by the state of Iran. And the state of Iran immediately nationalized the companies. And when they nationalized the companies went on asking for compensation, and the matter landed before the International Court of Justice. When the matter landed before the International Court of Justice, remember, the Iranian deputy foreign minister argued himself before the International Court of Justice. Of course, that is politics. We are not interested in it. He said, what compensation? For almost 75 to 100 years, you have exploited our oil. What you have given to our people? Did you invest anything to our people for the development of the state of Iran or the restful state of Persia? Every penny that we have got from exploring and exploiting oil is diverted to the state of England, and the money was spent there, or it is deposited some money so that you become rich. And you are asking compensation. Compensation is not paid yet. This is the thing.
Yes. So like we sometimes normally do, if you want to give a gist of the whatever session you have done, if it has to be summed up in 5 minutes, what will you say?
See, the first one is there are a few challenges facing environmental law today. Now, the Supreme Court has acted like the guardian in protecting the environment. It has acted like an educator. It has acted like a policy maker. It has acted like a super administrator. Now, in addition to this, there are certain principles that have emerged in international law. Although these principles are to be followed because it is being recognized in almost all the documents and conventions which are given to us by the international community through the United Nations Environment Program. But then at the time of implementation, they remain a dead letter because international law is a weak law. Although a weak law is nonetheless a law, it is not in a position to enforce it properly because of the differences in the Security Council. However, the contributions which are being made and the developments which have taken place by the way of the adoption of several principles of environmental law is a great feather in the cap of the almost all the people who have concerned in restoring justice and in protecting the environment. This is what I wanted to say.
Thank you, sir, for sharing your knowledge, and stay blessed. We are so happy that you have shed the weight for the better. Thank you, sir.
Thank you.